Hello and welcome to our latest Fenwick Elliott webinar. I am Jeremy Glover and today I'm joined by Roxana Vornicu to look at dispute avoidance in construction projects. We'll be discussing some of the options available to avoid disputes, and this is going to include a look at the Conflict Avoidance Pledge, and we're going to ask how it can work best for you. Full disclosure, both myself and Roxana are members of the Conflict Avoidance Coalition steering group. Indeed, Dr. Roxana Vornicu is co-managing partner of Sirbu and Vornicu in Romania, where she specialises in procurement, construction and administrative law. She's also been since 2020 a senior lecturer and research associate at King's College London. Specialising in public procurement law, her work at King's has included looking at procurement strategies for incentivising collaborative delivery to optimise whole life project outcomes. Roxana will be discussing collaborative contracts and dispute avoidance, but first of all, I'm going to take a look at the Conflict Avoidance Pledge. But before then, just our usual reminder, you should all be on mute, but please let us have any questions you may have during the webinar, and we'll put details of how to get copies of the slides into the chat during the webinar. And the actual full copy of the webinar will be going up on the Fenwick Elliott website in due course. But first of all, the Conflict Avoidance Pledge. Personally, I think it's becoming conflict avoidance, and the topic of conflict avoidance is becoming an increasingly important feature of construction contracts and projects. And by that, I mean, instead of people just talking about it, people are actually actively looking to see how to do it. How can they actually use the process? And I think the Conflict Avoidance Pledge is a good example, provides good assistance on some of the things that people can think about to what works best for you on your particular project, whether or not the actual pledge applies or not. Now, the Conflict Avoidance Pledge has actually been around for quite a long time. The steering group was actually launched back in 2018. But I think its potential importance, even back then, can be seen by the calibre of the founding members of the steering group itself. You've got CIR, RICS, ICC, DRBF, as well as some of the major employers in the UK, Transport for London and Network Rail. And of course, it takes time for ideas to coalesce, develop. And I think today there's a growing impetus behind the pledge. In the last few months, the steering group has quadrupled in size. And the pledge is also recommended for use in the construction playbook. If you note the language that's actually used, contracting authorities should adopt the Conflict Avoidance Pledge. It should be a standard clause in all public works contracts, and people should be looking to use the mechanism to resolve problems before they escalate into disputes. The construction playbook also notes that dispute avoidance boards are a good way to avoid and manage disputes more effectively, and it suggests that where appropriate, you should be looking to have a dispute board right from the beginning of the project. The construction playbook talks about inception to completion. So what about the pledge itself? And it is a pledge. There are a series of statements that signatories to the pledge would make. It's a belief in collaborative working. There's a lot of talk about the use of early intervention techniques throughout the entire supply chain. It's not just about the owner and the contractor. It's looking to involve everyone who is a party to a project, resolve differences of opinion, putting conflict avoidance mechanisms into projects, and that means putting them into the contracts to try and identify, control, manage potential conflicts. And yes, you do have to commit resources to do that, but better to commit resources to avoiding disputes than ending up in costly litigation or arbitration. Work to avoid conflict. So if you're becoming a pledge signatory, the idea is that it's a signal to your clients, your suppliers, that one of the ways that you operate is you look to deal with problems early. You look to deal with them amicably. And that's a key part of your day-to-day, everyday commercial operations. All businesses say they're committed to delivering value for money, but what you're actually going is you're going one step further. You want to work collaboratively to ensure that projects are delivered on time without actually disputes. And the language of the pledge continues. Developing capability, again, it talks about the early identification of disputes, the value of collaborative working, the importance of promoting and utilizing conflict avoidance mechanisms. And I think, you know, I think dispute avoidance is becoming more and more widely embraced, but I think conflict avoidance and the Conflict Avoidance Pledge, it's actually looking to do a little bit more. The pledge comes with a toolkit, and you can see that we've provided a link to the actual pages where you can find more details about the pledge. But the toolkit talks about the differences between dispute avoidance and early intervention. They talk poetically, dispute avoidance being about stopping the smoking embers of a dispute by bringing them to the attention of people who can actually do something about them. Early intervention is about snuffing out the smoking embers before they ignite into a fire. And how do you do this? Well, the toolkit talks about 5 particular steps, 5 particular stages of the project. Pre-contract, thorough preparation of project documentation, appropriate risk allocation, the first step in conflict avoidance. Most disputes on construction projects arise because there's conflicts in the contract documentation or because people don't understand what they're actually required to do under the contract. They miss deadlines. They don't understand what they're actually contracted to provide. Think about dispute avoidance. Again, there's a lot of reference here to early warning systems. The simple idea about raising your hand and saying that I think something's not right here. The earlier you do that, the better you identify a potential conflict. The easier it is to actually deal with the consequences of the problem. An obvious analogy is with a dripping tap. You know, you fix it, you fix the washer and it's done. You leave it, there's a flood. Same idea behind early warning systems. Early intervention, putting in a system in place to fix problems, enable them to be able to retain control of decisions and outcomes. Now, the idea is there to have a system in place so that it doesn't become odd that, for example, senior management might become involved to discuss an issue. If you already have something in place at an early stage, then it's part and parcel of the day-to-day dealings of the contract. Try and deal with things amicably. Let's talk about going from a mediation type method rather than more adversarial. Try and keep, you know, are you able to try and keep things private amongst yourselves? And when it comes to, if you have to resolve disputes, is it better to try and go through a process which leads to a final determination rather than have to go through courts and arbitration? But there's an emphasis here on setting up the project in the right way. It's an emphasis here on running the project, being aware of what's actually going on. And then that leads to potential dispute avoidance and management of those disputes. The Conflict Avoidance Pledge comes with a standard conflict avoidance clause. Agrees to cooperate with each other to identify early, avoid any disagreement between you. More importantly, there's reference to a conflict avoidance process. And I say more importantly because for some people, agreeing to cooperate with each other, well, what does that mean? It's a behavior. And one of the things of the pledge you've already seen, the references to collaborative behavior, communication, the way we actually interact with each other. It's all about a behavior. So it's going beyond perhaps the contract clauses, but there is a conflict avoidance process. And when we're talking about early identification of disputes, well, think about typical causes of claims. I've talked about uncertainty, people perhaps not understanding necessarily what they've contracted to do. Process problems, documentation is incomplete. People have unrealistic expectations, and quite often it's people issues. It's poor communication, opportunistic behaviour perhaps, but communication I think is key. It's the key to collaborative behaviour. But when it comes to the conflict avoidance process itself, it's fairly simple. Disagreements leading to a dispute should be referred to a conflict avoidance process. It's quick. There's recommended 17-day process. Obviously, if it takes longer, then the parties can agree that. And what you do is you refer the issue to a conflict avoidance process panel. And these are going to be a panel of 1 or 3 impartial professionals who are experts in the relevant field. So, you know, you might have a lawyer, you might have an engineer, you might have a QS, but you need to think carefully about the nature of the issues that have arisen. Now, the idea behind the panel is that they collaborate with the parties. They provide recommendations to try and resolve the issues in dispute. As much as possible, the panel need to be flexible. They need to be willing and able to adapt processes and procedures to suit the needs of the parties, reflect what's actually happening. They need to be able to understand the core of the issues that are potentially going to cause a dispute. So this is why there's such an emphasis on the early on identification of the key issues. And there's going to be some form of consultation process. It doesn't have to necessarily be a facilitative mediation type process. And I think because how else can you provide a recommendation or summary of findings and a statement of reasons unless there is going to be some form of evaluative component? But ultimately it leads to a recommendation which the parties can accept, and then it becomes a final binding decision, or you serve notice and you say you do not accept the recommendation. That's quite similar to how a dispute board operates, but it's a slightly different process. So what do the standard contracts currently say? Well, what about the NEC form? NEC form has an early warning clause. I think it's clause 15 of the contract. Parties required by their contract to identify issues, raise their hand about issues that might affect the cost and the duration and the performance of the works. There's a requirement for a discussion to actually take place to see what steps can be taken to reduce the potential impact of that issue. And there's a little bit of teeth to the clause. If parties fail to make an early warning about something they could have done, then the impact of that failure will be taken into account when it comes to assessing compensation. NEC comes with the compensation event procedure. It's a key concept of that procedure. And that's an example of real-time dispute resolution, real-time dispute avoidance, perhaps, because the idea is that parties establish the cost and time effect of the changes at the time each change actually occurs. That's the idea, agree the level of compensation now, or at least identify the reasons for disagreement at an early actual stage. NEC say the use of the accepted program, the joint use of the accepted program, that helps ensure collaboration. It also importantly helps provide certainty about what's going on. And then NEC talks about referring disputes to senior representatives. That can work because you're referring disputes to individuals who are not intimately involved with what's going on at ground level on the project. NEC also has options for adjudication and dispute avoidance boards. So I've almost managed to talk about the NEC form of contract without mentioning the overriding obligation at clause 10 about mutual trust and cooperation, a key element of collaboration under the NEC form of contract. And of course, that's all in part and parcel with the Conflict Avoidance Pledge. And also, it's now part and parcel of the new JCT 2024 form. You may know that the JCT released their new design and build contract about a couple of weeks ago. And what they've done is they've moved a number of clauses from the supplemental provisions to now become a formal part of the contract. And that includes Article 3, which deals with collaborative working. Parties work with each other in a cooperative and collaborative manner. There's reference to good faith and a spirit of trust and respect. And important that parties should support that collaborative behaviour. Now, we know that there are a number of cases from the courts dealing with the NEC form of contract where the courts will say if there's an obligation to act in a spirit of trust and respect, then the courts will take that into account if disputes arise. But it's an important step by the JCT from moving something from a supplemental provision to becoming a key component of the contract. The JCT have also moved the idea of referring to potential issues to senior executives from the supplemental provisions. And here, with a view to avoidance or early resolution of disputes, parties shall promptly notify each other of a matter that appears to give rise to a dispute or difference. So again, this is JCT trying to instill forms of behaviour into their contracts to encourage the parties to work together to help avoid disputes. Now, unlike the NEC, the JCT does not formally provide for dispute boards. I've mentioned them 2 or 3 times. Just briefly, the idea behind the dispute board, you have a standing board which is appointed at the beginning of the project, 3 construction professionals, ideally different disciplines. They have periodic meetings, which enables the dispute board to review the status of the project, review status of outstanding issues, and they can sense whether potential disputes might be arising. If you have professionals, they understand what goes wrong, they understand the simple steps that can be taken to deal with them. And if you have regular meetings, they get to know the individuals on the project. And the individuals on the project get to know the dispute board members. And so hopefully a degree of trust emerges so that if there are potential issues, the parties might respond and want to go to the dispute board and say, well, how can you help us? And one option is to seek opinions or recommendations as to the dispute board's view of the way forward. And they're not necessarily binding. Under many contracts, including FIDIC, they're issued at the request of both parties. In fact, I think what a good dispute board does is look to engage in early intervention, look to snuff out the embers that I was talking about earlier. And when it comes to dispute avoidance and dispute boards, FIDIC has long had or provided for dispute boards in their contract, and we have this FIDIC dispute avoidance practice note. FIDIC notes that the purposes of a dispute avoidance board facilitate the avoidance of dispute, and if necessary, carry out efficient and cost-effective resolution of any disputes that may arise between the parties. And FIDIC have raised 5 key questions in relation to dispute board, in relation to dispute avoidance. When should a dispute board make the parties aware of its dispute avoidance role? Absolutely, it should be doing so as early as possible. Many contracts provide for dispute boards to hold early site meetings, and they should do that. And again, partly it's so the parties understand what and how a dispute board can help you, but also it helps get underway immediately the idea of communication and people getting to know each other. Now, FIDIC's question 2 is when should dispute avoidance ideally take place? And FIDIC say when a joint request is made by the parties. And that's true up to a point. because the FIDIC forms talk about an informal opinion. And if you want to get an informal opinion, then you do need a joint request by the parties. But I would say, from a dispute board point of view, dispute avoidance should take place whenever the dispute board consider it's appropriate. You don't necessarily wait. There are ways to engage with the parties to try and better understand what's going on. You know, maybe to make parties aware that there may be some issues. I think the dispute board is there to be proactive, and you would want a dispute board to be proactive. So maybe I have a slight variance with the FIDIC answer to question 2. Dispute avoidance should take place where all parties are present, if appropriate. I think that's absolutely entirely right. And the type of matters that lend themselves to dispute avoidance, I mean, strictly, it's everything. There's always potential to try and avoid or resolve issues. Contract interpretation, that can be a good one to get a recommendation from a conflict avoidance panel or a dispute board, so you get an idea of where the land lies. Variations, number of ways in which dealing with variations are very suitable to the conflict avoidance process. And the most effective techniques for dispute avoidance, informal discussions, priority, that must be the first step always. See if you can resolve these issues without going down even the step of requiring a recommendation or issuing a informal opinion. But when it takes to talk about variations, yes, it's managing change, a key source of dispute when there's change to a project. But should the parties work together to deal with these variations? Well, of course they should. Sometimes it's a more binary issue. Are the variations standalone? Do they sit on the critical path? And it may be, and this is one of the difficulties and one of the reasons that can be problematic with variations, they don't initially sit on the critical path, but something happens later on and they might. And that's where communication becomes very important. But certainly agreeing parameters as how to measure and value change, now that's something that the parties can do at an early stage. You may well have agreement amongst yourselves. This is how we're going to apply the contract when it comes to valuing change. And that can be where a conflict avoidance panel or a dispute board can very happily help. They can provide opinions on issues of principle. Well, there's a small disagreement about how we measure overhead and profit. We could do this, we could do that. A dispute board or a conflict avoidance panel could say, well, I think that you should do this. And then the parties can take that forward and value the variation, and then no one has to worry about any form of dispute. And that's the idea, to help the parties avoid lengthier discussions later on. And I don't think it is wishful thinking. I've been on a dispute board recently where we've done just that. There were parties were trying to value change. They had agreement about how to do about 80% of the valuation. They asked the dispute board, well, what was our informal view on how they should deal with 2 or 3 specific issues? We gave that, never heard from them again. So that was a good example of how conflict avoidance can actually work. And there are a number of elements of conflict avoidance. Early warning's been almost on every 3rd slide, I think. So that's a key point. Contract records are quite important. How information's recorded and received. See if you can get some kind of agreement amongst yourselves on a project, because then you don't have a dispute about what's actually been happening or not. I've talked about valuing change. There's lots of ways you can use the contract to help you avoid conflict. Make use of programs, make use of progress reports. Standing dispute boards are a good idea. Idea of asking professionals, the conflict avoidance panel, to make a recommendation, so you don't have a formal decision or award. But above all, it's people. It's working together and it's working collaboratively. It's communicating effectively with each other on the particular projects. So moving sort of forward with conflict avoidance in 2024, and one reason why I think that the conflict avoidance process, the conflict avoidance coalition, is going to become a bigger and bigger feature of construction projects. The most simple reason is the UK government support. It's there in the construction playbook, and it's not just the UK government saying it, they're doing it. About a couple of months ago, the group working on the restoration and renewal of the Houses of Parliament, that sort of big project to renovate the Houses of Parliament, they signed up to the Conflict Avoidance Pledge. I think you're going to see more and more employer and owner organisations signing up, and there is going to be a change in the way that the construction industry works. I'm not saying that from idealistic point of view. I'm saying it from the point of view of how I've seen sort of way people approach issues. It has changed over the past few years. And one thing that the Conflict Avoidance Pledge can do, it can help you deploy the techniques that are right for you as an individual, you as a company, and right for the project to try and deal with emerging conflicts early on. But I think the key point is that this all needs to start from a very early stage in the construction and procurement process, and that's something that Roxana is going to talk about now.
Thank you. Let's see if I have the control of the slides. Thank you, Jeremy, so much for inviting me and for introducing me. As you've mentioned at the beginning, I live a double life in a way, because I work in various jurisdictions. At the same time, I own a law firm in Bucharest, Romania, and the construction sector there tends to be more antagonistic. So conflicts are a big part of my work there. At the same time, for the past years, I've been lecturing and researching and working with collaborative agreements and collaborative contracts. And I have to say that this has become a reality, not that it's becoming a reality, particularly in the UK, with the publication of the construction playbook and with the publication of Constructing the Gold Standard as well. So the industry is changing, and I think it's fair to say that it's changing in the direction of conflict avoidance and in the direction of collaborative approaches in the UK and in other jurisdictions on the continent. The Netherlands, for example, is a country where they tend to use a lot of collaborative agreements. And in fact, this is a very traditional instrument, contractual instrument there. But also other Scandinavian countries. So the kind of research that we are doing shows us that this is the tendency worldwide. I have a slide here with reports in the UK that have mentioned collaborative procurement and collaborative construction contracts, but probably I should have started further back with the 1994 Sir Latham report, which is striking because it does mention the problems of the construction industry, and they seem to be the problems that we're facing today. So it's encouraging that the idea goes so far back. At the same time, you know, it makes us think about it. Why haven't we really embraced these collaborative approaches entirely since then? Well, because the construction industry, as you know, is one of the most inert industries, but we're getting there. And I think that the publication of the playbook in 2020, with its focus on the collaborative delivery of public works, shows that we've made very good advancement. Another report that I do want to mention is a report that was published in 2021, Constructing the Gold Standard. It was drafted by Professor David Mosey from King's College. It's therefore a King's College research output, and it looks at framework agreements in the UK, but particularly it looks at the potential of collaborative framework agreements and at the strategies that do deliver better construction works. So related to what you said, Jeremy, clauses and contractual mechanisms are important, obviously, but it's important to bear in mind that if we want this to work, if we want our projects to be safer, to be greener, and if we want to avoid disputes, then we need to go a bit far behind. And I have here an image that is very suggestive of what an adequate procurement process entails, because basically we call it the 4 I's of effective collaborative contracting, and it shows that it entails a holistic approach, if you want. It needs to start with the first I, which is intention, and it's the strategy, basically. The client's strategy regarding what it wants to deliver, its credible plans and its credible commitments. So, you know, one of my clients once said, a project is as sophisticated as a client is. And indeed, it sometimes is true, because particularly in public works, and particularly with all the goals that we find, whether we're talking about EU procurement and the Commission's documents, or whether we're talking about the construction playbook, we want to achieve a lot of things with our public projects. We're talking about net zero carbon, we're talking about social value. So in order for us to do that, it is possible, but we need to have a clear strategy and the clear intention. Then obviously, we also need to have adequate procurement processes. So that the second I, it would be information. That procurement process entails tender documentation and evaluation criteria that is relevant for what you want to achieve. Of course, you do need to comply with all the procurement principles, you know, the traditional ones and the new ones under the new procurement bill, but that is not sufficient. That is not sufficient for strategic procurement. If you want strategic procurement, you need to specify the information and the way that that information is going to be exchanged down the supply chain. And you might also want to think of using methods such as early contractor involvement or early supply chain involvement, which are crucial, particularly for the delivery of net zero carbon result or social value. The third I would be the integration. And here we speak about the contract. So it's massively important, but it's one part of the entire puzzle. So contracts obviously should focus on what a construction contract tends to focus usually, which is clarification of risks and rights and obligations. But if we want to do it strategically, it needs to do much more than that. It needs to integrate teams. It needs to integrate suppliers, it needs to integrate managers, and it needs to have a clear mechanism of dispute avoidance and risk management. Because in the end, dispute avoidance is the tail of a bigger entity, which is risk management. And what we are arguing with our discipline in our study of collaborative agreements is that integrated risk management, integrated planning, integrated timetables are strategic instruments for the delivery of all those strategic results that the playbook is speaking about. And finally, the fourth I would be incentivization, which you can do via the management of the contract, but also via the contractual provisions. And this is exactly what collaborative agreements tend to include, incentives for good performance. So you are so right, Jeremy. The pledge is in itself extremely important, and our contracts are in themselves extremely important, as all what is behind the contract. Your strategy, your procurement documentation, your evaluation criteria, and the way in which you as a client manage that contract. This is what we call the 4 I's of effective contracting. And as I was saying at the beginning, the playbook is such a strategic instrument. And whenever I teach construction law, even to people outside the UK, I strongly recommend that they read this document because it's really a good example of a good strategy. And it's not only written there, but it's also happening. The playbook, the first version was published in December 2020. Now we have the updated version, published in 2022, and it also comes with a series of guidance instruments. One of them, for example, focuses particularly on the delivery of net zero carbon construction. The playbook mandates on a comply or explain basis 14 procurement policies. And I mentioned that it does look at the greener delivery of projects, but also at a lot of other methods for the delivery of effective projects, such as modern methods of construction, digitalization, BIM, early supply chain involvement, outcome-based performance measurement, and the use of benchmarking for a better understanding of costs. The playbook specifically mentions and recommends the use of collaborative procurement and the use of long-term contracts for portfolio of works, basically framework agreements. Centralization or aggregation of demand has always been a good strategic policy when it comes to public buying. So it is natural that the playbook mentions it, but it mentions it actually recommends collaborative framework agreements, not only framework agreements. So that's really an advancement. In addition to this, I was mentioning at the beginning, the strategies and the policies recommended by the playbook are much more ambitious than that, because they look at net zero carbon, they look at social value, they look at improved value, if you want, as a general term, which includes a bit of everything. So in order to deliver all these ambitious goals, you need a coherent and holistic strategy, the one that I was mentioning at the beginning, which includes the 4 I's of effective delivery of projects. For those of you who are not very familiar with collaborative agreements or with alliances, I'm going to give some real life examples further on. I'm going to speak particularly of FAC1, which is King's College research output and was published almost 10 years ago, and has been used in the UK and abroad on very different and very interesting projects. But in fact, what FAC1 can deliver, but not only FAC1, what collaborative agreements can deliver is an entirely fresh approach to procurement and contracts. And as I was mentioning, they are becoming the reality. Collaborative contracts can also deliver an alternative to the defensive and fragmented culture caused by the fear of disputes by providing a mechanism of joint decision-making, which I think is crucial for avoiding disputes, joint risk management and joint decision-making. And I will explain further on the mechanism under FAC1 for this decision-making, the core group, the alliance manager. How does it work exactly? And how does it help us avoid disputes? It obviously helps with other more technical aspects, such as the improved integration among design consultants, subcontractors, and manufacturers, and the integration of the supply chain. You know, and everybody knows, that innovation normally happens down the supply chain. And with the pressure that we are facing now, to turn our projects, to make them more sustainable and to deliver the net zero carbon target, we need to connect and integrate our supply chain. And you can do that via an adequate contractual mechanism, not via promises, not via a general obligation of good faith, not necessarily via a non-binding memorandum of understanding. That might work. Behavior is important. Behavioral workshops are important because they do influence our mindset, and they can influence the destiny of a project, but they're not sufficient. And they work or they don't work on an ad hoc basis. what we say is that contracts that do have embedded clear obligations of collaborations and clear mechanisms and consequences for breach of those obligations, it's not going to be a surprise whether they work or not. It's proven that they work. Collaborative agreements can also offer improved integration of capital and motivation for improved performance. That's the incentive in the 4I scheme that I was talking about. Most of the collaborative contract standard form have one way of incentivizing good performance and incentivizing collaboration. FAC1 does, PPC 2000 does, NEC option C does, and it's necessary, whether they are financial or not. FAC1, for example, offers the possibility of this incentivization and this motivation to be other than financial, such as, for example, net zero targets or other aspects of improved value, which are more complicated to monetize. But some of the incentives can be financial, and that's perfectly fine. And they can also offer a strong basis for collaborative working combined with clear legal rights and obligations, as I was mentioning at the beginning. What about this contract, this FAC1? What is it and how does it work in practice? It's called Framework Alliance Contract. It was created in June 2016 after 12 months of consultation with over 120 clients. Its basis, if you want, what triggered it was general frustration that bespoke alliance contracts can be hard to understand, can attract high risk premiums, and do not improve consistency or learning. So it's very user friendly and it has a very light touch, although it does include a clear mechanism for dispute avoidance, for joint risk management. It was initially created as a framework agreement within the meaning of the directive or within the meaning of the new procurement bill, if you want. But it has also been increasingly used as a project integrator. For example, when we have advised on the use of FAC1 in other jurisdictions than the UK with clients and contractors that were at their first experience with a collaborative agreement, sometimes the use of a project collaborative contract such as PPC 2000 would have been too much. The teams were not ready to go that far. So instead, what we've done is we've used FAC1 as an umbrella agreement, which came on top of the individual appointments of each of the members of the team, whether we're talking about the contractors or the subcontractors and so on and so forth. So the project contracts, if you want. Which created this environment of collaboration that went beyond a simple declaration of good faith and a simple declaration that we want to work collaboratively. So we did have a contractual mechanism with clear rights and obligations, but at the same time, each individual appointment was regulated by, NEC, JCT, FIDIC, whatever type of contract they wanted to use. Therefore, we had collaboration for a project that was not, and for members of the team that were not entirely ready to use a collaborative project contract. And I think this is the innovation of this particular contract, which is why I've chosen to speak about it. Its flexibility to be used as a framework agreement, and therefore to have call-offs underneath this framework agreement, but also the possibility to use it as an integrator, as an umbrella contract, because it supports a program of related or unrelated projects. We use it, for example, Crown Commercial Service uses it as their framework agreement, their collaborative framework agreement for the biggest framework agreement ever signed in the European Union, over £40 billion. So there, in that particular case, it supports and integrates programs of unrelated projects. But other clients in the UK, for example, the Ministry of Justice, has used it for its program of 4 prisons. That is a program of related projects. So we've used it in very different ways. We've also used it as a project integrator for a wind farm in Spain, for example, for one single project. Again, it acted there very differently. And can I say that it was also mentioned by the construction playbook as a good example of a standard framework contract that can achieve this and many of the ambitions set out in the playbook. And how does it work exactly? Why does it achieve? So what is the mechanism with which this contract achieves these ambitious results? Well, it helps to plan and integrate multiple projects or multiple objectives in the same project. It establishes that the alliance members include the client, the additional client, the in-house or the external alliance manager, and or any combination of selected consultants, contractors, suppliers, or providers. So the integration goes as far and as deep as the client wants, is ready to go, or is suited for his particular project. It states why the alliance is being created. It states agreed objectives, success measures, targets, and incentives. And these are binding for all the alliance members, so for all the members of the team. It also states how work will be awarded to alliance members under a direct award procedure and or competitive award procedure. This is obviously relevant when we use it as a framework agreement and not as a project integrator. So FAC1, it also states how the alliance members agree to seek improved value. It includes a definition of improved value, but you can also, the alliance members can also go further by defining their own objectives, their own success measures. It includes a risk register that is filled in and managed jointly, and a core group type of governance. Early warning, you were talking about it. They are indeed a prerequisite for dispute avoidance and options for an independent advisor and alternative dispute resolution. It also provides the flexibility to include particular legal requirements and special terms, which is exactly why it's been used successfully in various jurisdictions. So it's not in itself a project contract, but it can be used as a project integrator with any type of standard form, whether we're talking about JCT, NEC, PPC, FIDIC, any combination of standard or bespoke form. All its documents are treated as complementary. And there's an option for client to issue orders for pre-contract activities in advance of a project contract. You know how important pre-contract or pre-construction activities are in my discipline for a collaborative construction agreement. And for those of you who have worked with PPC 2000, you probably saw that this is a very solid process regulated under that contract. FAC1 doesn't go into that much detail, but it does regulate these pre-contract activities, which are vital for early contractor involvement and early supply chain involvement. The Eden project was one of the first projects where FAC1 was used. It was, in fact, an FAC1 prototype. So there we used it as a project integrator, not as a framework agreement. In that particular project, you probably know that it was one of a kind, so the technical challenges were particular. There, the main contractor, the team of consultants appointed under the multi-party framework agreement were integrated. And prior to integrate them via FAC1, each project agreement was awarded via an NEC 3 option C. Another example is the Job Center Plus. And it's interesting because it entailed 2 clients and 14 contracted bespoke contracts. So it was a framework agreement. The clients were public and private sector, and the 14 main contractors invested in common pre-construction phase processes and shared their supply chains under multi-party frameworks applied to over 960 projects. So this shows the type of complexity that this contract can help manage. The SCMG local government project is interesting, and all of these case studies are available either on the ACA website, where we have a lot of information on FAC1, or particularly this one, for example, on the government's website. This framework entailed the early appointment of Tier 1 contractors and Tier 2 and Tier 3 subcontractors. And it's a good case study because they used two-stage open book systems, early contractor involvement, early supply chain involvement, and they've had substantial time saving, substantial cost saving, and other improved value that was environmental, but not only. So really, really strategic contracting, if you want. And this one is the interesting Crown Commercial Service example that I've given you, the biggest framework agreement ever signed and managed in the European Union, again showing the type of complexity that FAC1 can help manage, as opposed to, for example, this small wind farm project. Well, it wasn't small, it was 250 megawatts, but as a project, it was small compared to, the Crown Commercial Service or the 960 project contracts. We've had 4 EPC contracts here. I was appointed as an alliance coach. It was the client's first experience with collaborative agreements and the 4 EPC contractors' first experience as well. They initially signed the EPC contracts, and afterwards they signed the umbrella FAC1. So they entered their EPC contracts without even knowing that this would be a collaborative type of project. So there was a lot of inertia and a lot of, if you want, mixed feelings at the beginning with the team who wasn't knowledgeable in these kind of projects and wasn't entirely committed to it. And the good results were evident from the very first core group meeting, and they grew in their wish to avoid disputes and in their wish to actually reach the incentives that were regulated, core group meeting after core group meeting. So it was definitely an example of success, not to mention that they managed to connect to the grid almost 6 months in advance, which did give access to good money to everybody. The last slides focus on how we avoid disputes, because as I said, collaborative agreements, we show and we teach that they deliver ambitious goals that are important for the society. But in the end, when you as a contractor or as a project manager are focused on a project, you're actually focused on finishing that project and avoiding disputes. So probably your mind is not so keen, not so focused on the ambitious societal goals. And what we are saying is that all this mechanism, all this contractual mechanism, is also helpful with the avoidance of dispute, because joint risk management should and actually does lead to the avoidance of a risk degenerating into a dispute. This Arcadis report does mention FAC1 and PPC 2000 as well, and basically tells us what we are facing in the construction industry. So how do we do it? How does FAC1 do it? As I mentioned, there is this integrated risk register. It's updated by the alliance manager, which is appointed by the client and can be in-house or can be external. And the core group approves this risk register. So basically, the risk management is undertaken jointly, and the risk register includes the description of the nature of each risk, the alliance member which is responsible for its management, the actions that will reduce the likelihood of each risk, and the agreed periods or deadlines for completing these actions. So it's a very clearly regulated process. They are regulated under Clause 9 and Schedule 3, and it basically helps the entire team decide whether for a certain risk there is a need for additional information, there is a need for additional tests, what are the additional resources that need to be allocated, and what needs to be improved in order to manage that risk. The last aspect that I'm going to look at is the joint decision making, which, exactly the same as joint risk management, is crucial, beneficial, and important for dispute avoidance. FAC1 does that via its core group. These are named individuals or agreed alternates which reach decisions unanimously by consensus of those members that are present at a meeting. So this way, somehow, it forces people to attend these meetings, because otherwise decisions are going to be taken whether they're present or not. The core group monitors and supports agreement of improvements under FAC1 and seeks an agreed course of action following the early warning system given by alliance members if any matter adversely affects or threatens the alliance. An equivalent core group system has avoided disputes under PPC 2000 contracts for the past 22 years, because we've only witnessed 5 court cases that 5 court cases related to projects where PPC 2000 was used. And FAC1 also provides options for appointment of an independent advisor and or a dispute board. So finally, Clause 15 and Appendix 4 provide for non-adversarial dispute avoidance, early warning, this consideration and joint decision-making by the core group, options for an independent advisor, conciliation and dispute board. And there are various declarations by various clients that state how FAC1 has helped them to avoid disputes.
Excellent. Roxana, that was superb. I was very interesting, and particularly interested in your use of examples to illustrate some of the concepts that you were talking about, because I think that's particularly important. And one of the questions that came in was actually asking if there have been any published examples about work under the pledge. And the answer to that is there are 1 or 2. Hopefully there will be more. But if you follow on LinkedIn the Conflict Avoidance Coalition, that's where you will start to find examples. There was an example put on the Conflict Avoidance Coalition page about a week ago, maybe 2 weeks ago, from someone who took part as a panel member, and he gave a redacted or anonymized version of some of the things that happened and why they thought that the process was a success. So I think the best place for examples is to look at the Conflict Avoidance Coalition LinkedIn page. Roxana, there's one question that came in for you. Are collaborative agreements better suited for public or private projects?
Well, I would say that they are suited for both private and public projects. You know, there's more freedom in the private sector. So obviously the clients there can use whatever they want. In the public, we do have the recommendations under the playbook. So clients somehow need to explain why they haven't taken the path of long-term partnerships and collaborative agreements. But yes, I would say that they are suited for both sectors. And in fact, there is a similar playbook for the private sector, which has more or less the same recommendations like the public one. And it also speaks of collaborative agreements. So definitely for both of them.
Okay, thank you. There's been another question that's coming in. I've been thinking about it ever since I saw it. Someone who'd be interested to know what measures in dispute situations could be considered to reduce the incident of adjudication, which the questioner says appears to be an approach taken by contractors for even the simplest of construction disputes. And I've been toying with it in my mind. It's interesting as a question because adjudication by some people is seen as a form of dispute avoidance, or at least alternative dispute resolution, because it's not, and so better than, so it's better than long-term court litigation or arbitration. And by asking how you can reduce the instance of adjudication, in one sense, what you're doing is saying, well, how can conflict avoidance or dispute avoidance work and be used to reduce it? So it's a really good question. And I think the answers lie partly in what we've both said about the importance of understanding your contracts. Lots of disputes arise because there's a failure to understand your contract. And the classic one in adjudication is the payment adjudications that are run when a date for a payment notice or a pay less notice is run. The sort of hit and run adjudications. So if parties understand the dates and deadlines they need to operate under, then that reduces immediately the scope for ambush and the scope for dispute. And I suppose the reason again is it's using the contract that you have, so everyone understands how the contract is progressing and the work's on the program or not, and it's using the progress. It's using meetings to discuss issues. So therefore you're discussing the issues. You're understanding at an earlier stage when things might be going wrong, or becoming more likely to people to jump to adjudication. So you may be better able to avoid them. Those are my initial thoughts. I don't know, Roxana, if there's anything that you wanted to add.
I agree with you.
Perfect. Always happy with that as an answer. But I see we're just over time. So I'd just like, Roxana, to thank you again for your super interesting talk about the FAC contracts and procurement, and some of the principles that, while they apply to FAC 1, actually probably apply to all procurement generally. So like I say, I think, you know, as 2024 progresses, people are going to hear more about the Conflict Avoidance Pledge. And if the government is saying you should be using it in government contracts, then everyone should be seeing more use of the pledge. And that might actually affect, you know, not just the contractors, but subcontractors, suppliers, as you move down the supply chain. It's meant to work for everyone on projects big and small. But just as a final word, to say that thank you, our audience, for joining us, and thank you for your questions. And our next webinar will be on Thursday, the 16th of May, in about 4 weeks' time, when my colleagues Ben Smith and Hugh Wilkins will be providing another update on the Building Safety Act. There seem to be many changes, both in legislation and now issues arising out of the courts. So anyone with any interest in building safety, thoroughly recommend our next webinar, Thursday, 16th of May. But once again, thank you all very much for attending, and goodbye.
Thank you. Thank you, Jeremy, for inviting me.